all these things sort of, maybe there's a second and all of that. But just to anticipate that, some people ask, how can we possibly, operate if we can't debate until there's a motion and a second? Anyway, so I'm moving on to voting here. Under Robert's Rules of Order, the basic rule is majority vote required, 50% plus one. But then you ask 50% of what? So 50% of all votes cast by persons legally entitled to vote, excluding blank ballots and abstentions. So it's not 50% of the body, it's not 50% of the quorum, it's 50% of the votes cast. Note the effect of abstentions. If a rule required a majority of all members present, an abstention would count as a no vote. But that's not the case with the Robert's Rules of Order. So you have in your bylaws how the voting majority works, and that overrides this. But Robert's Rules of Order, majority of votes cast. I guess that's like the election for office. I'm sorry, just real quick on reconsideration. Boy, thank you for your attention. The rule on reconsideration enables a majority of the assembly to bring back for further consideration a motion already voted on for a standing committee, which I would say this is a standing committee, has a regular schedule. There is no limit on the amount of time elapsed since the vote was taken. You can still ask for a reconsideration. No limit on the number of times a question can be reconsidered. The motion must be made by a member who did not vote with the losing side. This is different than, like the county rules, you have to have voted on the winning side. This allows people who didn't vote at all, who were absent, for example, to bring a motion for reconsideration. So any member who did not vote with the losing side. Next slide here. Unless all members who voted with the prevailing side are present or have been notified that the reconsideration will be moved, it requires a 2/3 vote to adopt the motion to reconsider. I had distinguished the rule for large assemblies in which a motion can be made only by a member who voted with the prevailing side, meaning the motion could not be made by a member who abstained or did not vote at all. So that would be for a large assembly. That's all I have on Robert's Rules of Order, kind of covering quorums and voting and how you make a motion.
Can I ask a question? We have two commissions here. So the Camarillo Airport and the Oxnard Airport. At any time, can we vote all together?
I think you can. To me, the question is as long as it's clearly recorded, that it's clear what the vote was.
Okay.
I think as long as you satisfy that, then you're okay.
Okay. I just wanted clarification on that.
Yep.
Does anyone else have any other questions?
If we were going to vote together, it'd have to be one of those things that it was,
On an item.
it pertained to both bodies.
Correct.
Because
That's what I'm stating.
everybody voting together on somebody else's doesn't conform with our bylaws.
No, I want to make sure I was clear. It was only on items that are for both parties, that both would. You only vote on what item is on yours. Thank you for making sure that was clear. I did notice that I have 2 speaker cards. Are there any other questions from the commission? Okay, and then also, before I get to the speaker, I would like if we could possibly get these PowerPoint sent to us. I saw a couple of us taking pictures, and so it might be helpful to have this that we can reference in case for any other need. The first speaker I have, excuse me, Jorge, you had a question? I did see your hand.
Yes, my only question was, we have different joint powers authorities, and we have to record the votes. So it is a staff's preference to keep them separate, just for record keeping.
Even on meeting notes?
That would be correct.
Okay, thank you for the clarification.
Thank you.
One thing, normally on the cards, people don't have to fill out a card, don't have to share the information. But one of the things that I'd like to see is if they want additional information mailed to them or even have a phone to call them back. That would be an ideal thing to have. But like you said, they don't have to fill out a card or so forth. But normally, if they want a response on a particular issue or information, it'd be appropriate to have that name and the phone number.
That'd be fine. You can always ask for that and
Yeah.
offer that.
You're right.
All right. The first speaker I have is Mark Sullivan. You have 3 minutes.
Thank you. Thank you very much. I hear loud and clear the comment that this authority is going to let people be heard. That's really not our concern. We know that we can come in and we will be heard. The real concern we have is, A, will individual members of the authority be able to vote on it or to participate in it, this conflict of interest issue? And secondly, will this authority as a whole be able to make a recommendation to the county? We're going to have a discussion. I've got a speaker card on the bylaws, and we're very concerned about some of the changes in the bylaws because it appears to be unilaterally giving up jurisdiction or authority to make recommendations or even to take comments on things except as they're narrowly constrained by the language. I'll address that later, but those are the two overriding concerns. The big issue I have at the present time, and my client, the Ventura County hangar owners have, is that I've provided you with a letter that I wrote to Supervisor Long, and it does address Section 1090 of the Government Code, the Contracting Code. And I hear County Council's argument that that the Fair Political Practices Act is a different and more strict law. I have a problem with that. And the problem I have with that is that the California Supreme Court, in the Lexon opinion, I will grant you, as the Supreme Court frequently does, it didn't address that final issue that does this equally apply under the Fair Political Practices Act. However, it does say unequivocally that the two laws must be harmonized. Now, if you think about this logically, the Public Contracting Act is saying if you have one of these indistinguishable interests, you can vote on a contract that gives you a benefit. I gave you a copy of an Attorney General opinion where a mayor voted and got $25,000. That's a nice benefit, correct? But it was indistinguishable. Therefore, it was okay. The California Supreme Court says you must have the two acts coincide. The Political Practices Act governs any governmental decision. So if you were to think about Venn diagrams, you get the big Venn diagram, that's the Fair Political Practices Act. And then you've got the narrower one dealing with something even more serious, contracting. And you can do it under contracting, but you can't under the other law. In other words, you'd have two laws in patent conflict with each other. Supreme Court says in Lexon straight up, we have to harmonize them, and then it cites language that I quoted in my letter, and I would ask you to please look at that language on what it means to have, representative members on commissions. This applies more to the Aviation Advisory Commission than to this authority, but it clearly applies to them, that their whole organization is meaningless if you're going to bring in people that know about a given operation because you want their input and people like them in the community that they're representing, and then you say they can't participate and they can't vote. I submit the only answer is that we really do need to request an opinion of the California Attorney General rather than just run away from this issue. But the only person that can do that is the DA or the County Council, per statute.
Thank you very much. We'll give this letter to, I think this letter has been already given to County Council. Thank you. Next is Scott Barra.
Council, I didn't get your name. I apologize. I appreciate the presentation you made. Leroy. If you would be so kind as to put up the section that dealt with leaseholds of 30 days or less. I just had a question for you.
Sorry.
Okay. So under that section, under California Code of Regulations 18233, if a member sitting on a panel, like the Advisory Commission, for example, has a lease that's a month-to-month lease, at the time they're voting and the lease is a month-to-month lease, under this statute, there's no conflict, correct? I would agree with that. Thank you.
Okay. Those are the two public comments. Does anyone else have any questions? Mr. Smith, thank you very much for the overview of all this training. I really do think it helps our board and for us to lead in a better way and more improved. This is a receive and file. So do we need a motion?
Madam Chair, I just want to thank Leroy for excellent presentation, and I think, we talk about the Brown Act and Robert's Rule of Order, and you think you know it all, but it's kind of nice to review it, over and over again. And
Move to receive and file for the Camarillo Authority.
Second.
First, we'll do it for the Camarillo. So I have a first,
I'll second.
second. Any questions? All in favor, say aye.
Aye.
Any noes or abstentions? Camarillo Authority approves. Moving on to the Oxnard.
Move to receive and file.
Second. All those in favor?
Aye.
Good. Motion has been approved. Both have approved.
Thank you for the
Thank you very
presentation.
Thank you.
The next item is the feasibility, creating the appeal process for termination for month-to-month lease for aircraft hangars, storage hangars. If you could take this one on. Okay.
I mean, I can say that I agree wholeheartedly with the memo. In fact, did I sign it, or, it's accurate, and I'll repeat a little bit, I guess, what I said to the advisory commission in street language. The memo's technical and has legalese in it. The basic issue is you can't have an appeal process for a month-to-month lease. It doesn't make any sense. There were two alternatives. One, if you had an appeal process and you had something to actually look at, such as conditions, causes that the county had to have in order to terminate a month-to-month lease, now you actually are converting that leasehold into fee interest, because it couldn't be terminated except for a cause, which is the same as a fee interest. So there's nothing for the appeal body to rule on, because you can't establish criteria that you must meet in order to terminate it. Or else you're converting a month-to-month lease into a fee interest, which I don't even think, then you got big issues about gifts of public funds, about if you're going to actually sell real estate, do you have to sell it to the highest bidder, that sort of thing. The other alternative is we won't establish any causes, any conditions for terminating a lease. We know about the conditions where if the lessee does something and they're in breach, but this contemplates the county must meet some test before it exercises this right to terminate. So you can't really put cause conditions out there. The alternative is you transfer to some other person other than the airport director or the board of supervisors the discretion to terminate a lease. And what the memo says, and I agree with, is the board of this is a power of the board that they have the duty to exercise, and they can delegate it to an official, but it has to be tightly constrained, and you can't just delegate it to another body separate from the county that's not constrained with parameters. So, not that the board would ever even want to do that, but there's a legal constraint about the board abdicating its responsibility totally and just granting to some appeal body, even if it's the authority, the discretionary power to terminate a lease. So there's really no rationale for having any kind of appeal process other than trying to second guess the person who exercised the power or to rule on some new cause that's going to be situated. That's the reality of it. And I think the other thing I'd like to express is, I think there's a lot of argument, like, I don't think it's totally honest. We all know what a month-to-month lease is, and we know what a ground lease is. You can't convert a month-to-month lease into a long-term ground lease by arguing. And all we're saying is month-to-month leases are month-to-month, and they could be terminated for any reason except an illegal reason. And that's all that we're trying to do. Now, Tom's memo essentially covers that with legal jargon.
I have a question here.
So it's relatively clear when you have a for-cause termination, and there is a process involved in a series of things that have to happen with the for-cause termination. When does a non-cause termination evolve into that same process? Because if you have an arbitrary cancellation for cause, then you end up having to go through a lot of the same processes as a for cause termination, the way I read it, because once you take that first step and say, hey, wait a minute, there was no reason for you to have terminated me except that you were being prejudiced or you were being this or that, and then pretty soon all you have to do is say, I'm not leaving, and then it goes into the same process as a for cause termination. Do I understand that correct?
I don't think that's correct. I don't know if you want to, I mean, there's no such thing as a no-cause termination. The other thing is, you don't need a reason. You don't need a cause. You just can't have an improper reason. That's the rule. So everything else, all the other process is in place because the legislature has put in place a lot of procedural protections for tenants. So there's the unlawful detainer action, and it's different if it's a failure to pay rent or if it's just a failure to vacate. But it's an expedited process. And the way to raise, if somebody thought they're being evicted because they're black or because they're being retaliated against for some improper purpose,
Right.
they would raise it as a defense in the eviction process.
Right, which,
You couldn't evict someone for an improper reason.
exactly right. But tell me what is the difference in the process once it hits that point? It's the same process, right?
Well, I don't quite understand.
If you said I was being evicted and no cause was listed at the end of my 30 days,
Right.
and I said, there is a person on the airport that's after me, and he's doing this out of prejudice because I've upset him, and I'm not going to leave on my own without going through a process, then that process ends up being nearly the same process, if not the same process, as the eviction for cause, where you go through,
That's not correct at all.
okay?
You know, there's nothing illegal or improper about evicting someone because I don't like you or because you're a pain. That's not illegal. It's illegal to terminate someone because they're black or they're female or they're over 40 or they're disabled. But that's not an unlawful purpose. That person's in no different category than a saint who everyone loves, but yet gets evicted.
Madam Chair.
Yes.
Maybe because we want to build something on that lot or whatever.
But see, at that point, there is a cause. I think that the problem, there's a reason, and to have that being non-visible sometimes feels like it's,
This is the nub. Do you want an appeal process of the reason? And some advisory body's going to have a public hearing over the reason and whether we think that's a good reason or a bad reason? But it's not, none of that's required. You could do that. But
Okay,
Leroy,
Supervisor?
that has nothing to do with a month-to-month.
Right.
But however, they can go into litigation over,
it's hard to evict somebody these days. You know, there's a lot of procedures that go.
but it has nothing to do with the month-to-month, as you were saying, because that's two different issues, right?
Month to month just means you have no expectation of length in your lease. You can be evicted on 30 days' notice because the law requires 30 days' notice and a court hearing.
And that's in the real estate law too, you know.
Absolutely, and if you don't pay rent, it's 3 days?
3 days and then.
But if it's for a reason other than not paying rent, it's 30 days. And it's just because legally, you got to give 30 days' notice.
But as Bill's saying, if the landlord doesn't like you or evicts you because he hates you, that's a legal matter, not a
Appeals problem.
you know,
It's not illegal to hate somebody. It's illegal to hate somebody for a bad reason,
Yeah.
for a protected reason. I mean, that's
Yeah.
how the world works. I mean,
Commissioners, do you have any questions? I have 3 speaker cards.
Okay.
Okay, I'm going to take the speaker cards. David Timms is the first one up, 3 minutes.
Thank you. My name is David Timms. In the ad hoc meetings, the question frequently came up regarding application of all the stipulations in the proposed lease agreement, and it wasn't just related to eviction; it was related to anything that's in the proposed lease agreement. For instance, if the director of airports said, "I want you to paint your hangar," well, it doesn't need painting. It's in better shape than other hangars that are not getting painted. We'd like to have a process stated in the lease agreements to have an appeals process. And it's not just for an eviction process. It's an appeals process for what the Department of Airports is saying we need to do. And perhaps it's unreasonable. In fact, it may have a dispute between what the FAA says is required or the FAA is not required. And we want to have a process so that you can go to the commission or the authority and say, I'd like to have the authority or the commission hear this and make a decision on it. It's not simply for eviction, it's for anything that's in the proposed lease agreement. Thank you.
Thank you very much. Mark Sullivan.
County counsel hit it right on the head. He said if the standard that he's arguing for, if something's not unlawful, basically how the world works, it can be totally arbitrary, and they terminate the lease. What the Hangar Owners Association's big concern is being subjected to an arbitrary action and having no remedy other than going to court. It can't possibly be in the county's interest to say that your only remedy is to have a lawsuit, given the fact that the simplest lawsuit's got to cost $30,000, $40,000 to defend. And it's also, we think it's bad governance that, having some remedy, if there's an action that people believe is arbitrary, that isn't going to be dismissed after a 2-minute hearing, if it has some substance to it, by definition, some authority should be able to hear it other than having to run off to Superior Court. That's the point. And there's nothing, I've seen County Council's letter, and County Council's letter cites authorities on what counties can do. None of those authorities say that it's illegal in any way to have a review authority. And simply all people are asking for is to have some protection other than having to go to court for arbitrary actions. And there's a myriad of ways things can be arbitrary. There can be questions about how often should you paint your hangar, what color should it be, the list goes on and on and on. And you can't always be sure that if there's no recourse other than a lawsuit, that you're going to get a reasonable hearing. That's it in a nutshell.
Thank you very much. Scott Bear.
Hello again. Council, you raise a good point, and Supervisor Saragosa jumped on it a little bit, that the remedy for someone who feels they've been arbitrarily evicted is to go into Superior Court. Well, I think everybody here would agree that the purpose of government is to serve its people and to serve its constituents. Elected officials have constituents. We're residents of Ventura County. We're your constituents. So rather than force us to go hire a lawyer, I'm a retired reformed litigator, so I know what litigation's all about, and it is not a place you want to be. Rather than take people in this audience who have hangars and force them to hire a lawyer and pay a lawyer and go to the court and have to deal with what court presents and the mental stress that court presents, why not do something for the hangar owners and for the hangar tenants and for your constituents and set up an informal process to try to resolve any dispute that might arise out of an eviction or an arbitrary order by the county? Why force someone to go hire a lawyer, go to court, take Mr. Temple's time away from more important things, and he has to go to court and deal with that sort of stuff? There's just no good reason not to set up some sort of body that would attempt to resolve these issues. And to sit here and say, well, we have the right to do it, so we're going to do it, isn't a good enough answer. Because that's a lawyer's answer, and I mean that with all due respect because I'm a lawyer. The issue really is what's best to serve the constituents of this county and the users of these airports. And it's not to say, well, damn it, we can throw you out, so we're going to do it. The answer is, let's come up with a process that'll let people feel like they're being treated not as commodities, as constituents, as taxpayers, as people who pay their rent every month. So I'd urge you all to not just adopt this view that, well, we can kick you out because we want to. And I think Mr. Rubio said at one of the last meetings involving a tenant that we're exercising our right to be arbitrary. And that's just wrong. So I urge you all to reject the notion that you can do it because you can do it, and instead think about the humanity involved. Think about the people that are affected by this, your constituents. And I'd urge you to go a different direction. Thank you.
Madam Chair?
Yes.
No, I didn't mean to say that we should go to court right as a remedy. What I'm said, the question was a month to month, that's a month to month. And one remedy is to go to court. But I'm sure that Mr. Rubio and I'm sure that any manager is going to sit down with you and give you chance 1, chance 2, chance 3, and so forth to remedy whatever is happening with the rent.
Well,
And I mean, I like the idea of what you said about having a review committee look at it.
It's what we in this world, in my world, and council's world, Mr. Temple's world, call an alternative dispute resolution.
Sure. But
it's a way to, rather than force people to go into court, come up with something more humane.
But I'm not saying that go to court for everything. That's not what I'm saying. I'm saying that that's a remedy. That's one way.
Understood.
But, I'm sure that if you bring up somebody didn't pay the rent because they didn't get paid and you're late, I'm sure that Mr. Rubio said, okay, I'll give you 20 days or 30 days or whatever, or work with you. Or work with whatever problems we have. But that's one option. I'm saying, hey, if you don't pay your rent, you're going to court. That's not what I'm saying.
I appreciate your comment, Supervisor, because I think that's helpful.
Yeah.
The problem, my immediate reaction to that is, and I mean no disrespect to Mr. Rubio, but he did make a statement at one of the last meetings that we're exercising our right to arbitrarily.
Yeah.
I understand, Supervisor, but I'm responding,
Yes,
trying to engage in a
Yeah,
productive dialogue.
I think we should work
He
with
did say we're exercising our right to be arbitrary. And that scared the heck out of, I was going to use another word, but I'll be politically correct. That scared the heck out of all of us when we heard him say that.
Right.
So please, I would urge you to take a look at, and we're happy, the Hangar Owners Association will engage in some sort of committee. I'm
Thank
wrapping
you.
up. To work with you guys to come up with something, but I would
Thank
urge you,
you.
please don't just adopt the arbitrariness that council is advocating for.
Well, what I'm going to interrupt you, and thank you very much for your comments. I appreciate that.
Okay.
What we asked for, I think.
Madam Chair,
Yes.
I just-
Do you have another question?
Well, just to weigh in on this, and I'm fearful that we're violating the Brown Act by interacting with a member of the public, so I have a concern about that, since we did have an excellent presentation here by the attorney. So, this is not a court of law here. This is not a courtroom. It looks like one. It's not a court of law. It's a legislative body. It's an advisory body. And my first question is we would what has been proposed? It's only the Board of Supervisors that can do this, correct? We're only an advisory board. We can't make that decision. Is that correct?
But you can recommend.
That's correct.
I understand. Yeah.
No, that's
Right.
correct.
And
I just want to say I'm fearful because I've been cited for violating the Brown Act for something similar to the public interaction aspect. So I'm just a little concerned about it. That I'm addressing my questions to staff. I want that to be part of the record, not to a member of the audience. So the other thing I wanted to say is, to me, this is more of an issue of should a public agency be allowed to have this kind of bottom line rule, really. That it, rather than an appeals process, it is like, as an example, you go to a private business. This is a public entity, but you go to a private business. We reserve the right to refuse business to anyone. You're in a private business and somebody doesn't like you, they can kick you out for any reason. But if it could be proven that you're being kicked out because of the reasons that you stated, that person's going to be in a lot of trouble. So I think the way I'm really hearing this is that should a public entity have an appeals process, and it's really problematic because what it in essence is that it would be a board that it would have to go to the Board of Supervisors, really. Because this advisory board, I don't see how could this advisory board advise the Board of Supervisors that they should undo what the administrator did? So it could only be the Board of Supervisors that, and it's not a court of law. It's just not. And so we have, as an example, code enforcement actions, and they go on people's property taxes and at the end of the year. And once a year, we hear that. And the bottom line is that individuals will come and ask the mayor and the city council to act as an appeals board. We're not an appeals board. The person has a right to address the legislative body, but we're not there. And then sometimes there's some interaction with the staff. Can you work with this person? Can you do that? So I don't know where the happy medium is. I would just say that we are in a situation where, on the one hand, let me tell you, I have never, in the 14 years I've been in public service, seen something more contentious than the issue of these, the rent increases. It doesn't matter how much they are. I've never seen anything more contentious in my life. And I've never seen anything more contentious than challenging the legality of one individual's right in a public agency to render a decision. And how do you deal with that? And I have to admit, as a decision maker, I'm a little bit perplexed about how best to remedy what has been proposed. I can't necessarily say we should have an appeals board because I'm going to recommend that the Board of Supervisors here, where their administrator has it out for somebody. I mean, talking about wasting, it just can't be that. I just don't know how it could be constructed. So I guess the final question is, the suggestion has been that someone other than the Board of Supervisors act as the appeals board. So I don't know what your perspective is on that. Is that even legal?
Well, I have serious doubts that it's legal to give the ultimate power to someone on an appeal board, because really what you're saying is someone has to make the final decision. And it's either the Board of Supervisors or it's the airport office. So if it's someone other than that, it's very problematic and maybe not legal.
Council, can't the supervisors delegate their authority?
But
Sir, I apologize, but since we just went through our rules and so forth, we've been able to provide you 3 minutes, just like every other constituent that's here. So I'd have to ask you to sit. I apologize, but those are the rules in which we've all reviewed today. One thing yes, and you know what, that's what I was going to state, was the fact that we can have you talk to him afterwards and go into deeper discussion. Today's motion is a receive and file. There is no action going on today. I want to make sure I remind people of that. I asked to make sure that this comes up because I think it's very important that we're transparent to our board and getting knowledge about what is could we or could we not get an appeals process? Because we have all been approached by that. And what are the questions? And I want to make sure everyone is educated on what we can and can't do. And also, we are going into negotiations. We're still not finalized. We're still working with everybody. And we all need to understand what our limits are. And so I appreciate that we're having this discussion today, but I remind people, because I know how sensitive we all are, that there is no action being done today except for reviewing a process. So I'm very sensitive to that. I just want to make sure you guys know that.
Can I make a
Go
motion
ahead.
to accept the
For, yes, hold on one sec. Leroy, did you have anything else to add? Okay, so can I get a motion from the Camarillo Authority?
Camarillo, so move.
Is there any other question?
Well, you were looking at him when you said Camarillo. so-
Well, John is on Camarillo. John's on Camarillo as well.
Okay, I'll second.
That's first and second. Do you have discussion? Yes.
So, I've read the reports, I've read the county council statements, et cetera, and in my view, it seems that the discussion of an appeal process is invalid because we can't really tell the Board of Supervisors or the Department of Airports make a decision for them. It seems that delegation of that authority to us is not appropriate. And second of all, I don't know and I don't think we have the expertise to make those kind of decisions. And that's my comment, so.
Thank you very much. You had another comment?
I think that the crux of the issue is sort of a loss of confidence in the process more than the process itself. And while I will vote for filing, I will also want to nearly insist that this gets raised again because of some of the issues that I see with disagreements in whether termination without cause is as clean as the law would like.
Thank you very much. Anyone else? Okay, we'll move on to our vote. All in favor, say aye.
Aye.
Any noes, abstentions? Motion has been approved from Camarillo. Moving on to Oxnard.
I thought we did vote. Yes, let's vote again.
Motion.
Just a question. I think the gentleman had something he wanted to say.
He did it.
Sean, did you have something to say? Paul?
No, I was going to actually echo some of Bill's sentiment.
Okay. Thank you.
That's right. Can we go ahead? Sorry.
Make a motion?
All those in favor to receive and file?
Yeah, second.
All those in favor?
Aye.
Can I share something
No
real quick?
noes or abstentions?
Leroy,
Motion's approved.
I'm sorry. The Board of Supervisors hire agency directors to make recommendations to the board. And if whatever is shared here by this board to the agency director, then that recommendation goes to the board for whether it's an appeal process, whatever happens here. Am I making sense? No. Okay. Let's
I couldn't follow it.
Let's say we talk about an appeal process.
Yeah.
And the vote says maybe we ought to look at an appeal process.
Right.
And maybe the agency director should be the person that should recommend yes or no. On
Okay.
the appeal process. Is that,
Right. Well, I'm just
as
saying.
opposed to going to the Board of Supervisors and the Board of Supervisors?
I think the authority can make a recommendation to the Board of Supervisors.
That's what,
to adopt that policy you just described.
right.
And the board could
Could
consider
say yes or
that
no.
and, accept it or reject it.
Or
But you certainly, that's part of what the authority would do, is to have a hearing like this, and if they think the airport should change, or, excuse me, the board and the airport should change, you could make that, this body makes that suggestion.
And then the Board of Supervisors can come back and say to the agency director, okay, set up a committee, do
They
whatever.
could say yes or no, or something in the middle.
Yeah, okay.
Thank you. Okay.
Thank you.
All right. Moving on. We got 5C for the review and approval of bylaws for the Camarillo Airport Authority and the Oxnard Airport Authority. Thank you very much. We have cards, so we will need to be reviewing this. Do you want me to lead, or I think you guys should?
Well, I will just mention that we did have a special meeting where the Department of Airports, along with County Council, were asked to review the bylaws. This initially came up because the public member term was up, and we wanted to review the bylaws just to make sure that they were consistent with the joint powers agreement with the county and each of the cities. So we brought language to your body at the special meeting that we held. We heard the public testimony. We also heard the discussion that your bodies had with each other, and some of the language was proposed to be modified. What the Department of Airports and County Council did is we highlighted in yellow the areas that were requested to be modified in order to accomplish those. And there's only a few of them for Camarillo and a few of them for Oxnard. But basically, the other changes that you see there were basically adopted at the, I wouldn't say adopted, but they were discussed by your authorities at a special meeting. So I don't know if you've had an opportunity to review, but the discussion is yours if you have any questions about the bylaws in the yellow highlighted areas.
Question.
Yes. Charlotte.
Do I understand correctly that the only changes to the existing bylaws are highlighted in red or printed in red or having something to do with yellow? And I don't understand the distinction between the yellow and the red.
I know it may look confusing.
I'm going through the red line copy, I'm sorry.
Okay, so the red line copy, which in a way I highlighted with yellow as well. What you see there that doesn't have much of yellow on it, there's typically a comment, like for example on attachment 1, page 5C3. When you look at the date 1976, 1979 on the first paragraph under Article 1 Constitution, I made a comment to the right that says corrected to 1976 per the special meeting. I think that
The yellow changes or the yellow comments all pertain to the yellow changes,
correct.
highlighted yellow.
Correct, and those are the changes that we did previously. Now, there is one distinction where when I wanted to print this and provide the yellow highlighted areas, not everything was highlighted when I printed it. For example, the comment towards the bottom, comment RJ4, where it says clarification per special meeting request to include the government code. And that's a highlighted area. So it's basically the language that got rewritten and that is provided to you by Mr. Tom Temple and I. And you can see the paragraph, I mean, not the last paragraph, but the previous to last paragraph in that page. Some of the words changed, but it was just to make that clarification as to what the intent of the duties and responsibilities are of the airport authority.
So there's really no difference in the comments on the right that are highlighted on yellow, and I didn't know if there was a significance to the fact that some of the comments had yellow and some had just red.
The comments that have only red on the sides, those are the comments that were provided to your authorities last time, and we went through them. I didn't touch them because, for the most part, they were adopted. Anything that's yellow right now is, I think, what we should be concentrating on. I mean, we have to look at everything, but I mean, the highlighted areas is where we made those changes for this meeting.
Madam Chair.
Yes, please.
Do I understand that on the changes to the bylaws is that we could change the things that were not in the JPA, but if they were in the JPA, we weren't going to mess with the JPA?
So we're trying to make the bylaws as consistent as we can with the JPA. There was some discussion as to probably not including some of the items that were in the JPA here. I think one of them had to do with potentially this body being subject to lawsuits and who covers it and whatnot.
Yeah.
So that changed.
Well, in particular, I'm looking at comments RJ2, which is a part of Article 2, that takes out the 4/5 override section by the supervisors, but that certainly is in at least the Camarillo Ventura County JPA on paragraph 13 in the JPA that lists that's one of the requirements. And County Council suggested that the board couldn't delegate that, but that's one I disagree with.
You disagree with it being removed?
Yes.
I'm sorry.
So
I believe it should remain in, and it's crossed out and removed from the final version, which is Article 2 purpose.
Well, and that's a question too, because it's in the JPA, does it have to be redundant in the bylaws? Because you're transferring from one to the other to make it consistent so you follow the rules. Maybe it makes sense to keep it in so that it's consistent with the JPA versus the JPA already says it, so why are we talking about it in the bylaws?
Right, and we did discuss this issue when we had the special meeting, and the question was really, it boiled down to, as I understood it, whether these bodies, speaking of Camarillo at this point, whether the Camarillo Authority must review something before it goes to the Board of Supervisors. And the bylaws, as they are amended, still say that. And so the language that was deleted here, it doesn't really remove or alter any of the powers or requirements, duties, et cetera, of this body. It simply makes it more clear that if something is going to be referred to the Board of Supervisors, it has to be heard by this body first.
But it totally took out the authority piece of it, so that if a recommendation from the authority went to the Board of Supervisors on a particular topic, and the Board of Supervisors didn't want it, they had to have a 4/5, 4 of the 5 supervisors would have to be there to overturn it.
That is stated in the JPA.
Right, and it's been removed from the
Whether or
bylaws.
not the Board of Supervisors must act with 4/5 vote is not within this body's purview.
Exactly, but I'm not quoting this body, I'm quoting the JPA.
So to be consistent, can we keep it within the bylaws just to make sure no one didn't read the JPA?
If an item is listed in the JPA, yes, you could list it in the bylaws as well. It's simply a question of whether, what purpose that serves.
Well, I prefer to leave it in, just to make it clear, because some people read one and not the other and don't understand.
I think that's a valid point. So that's
I would agree.
RJ2. All right?
I'm sorry?
So.
I have to apologize. My hearing is severely diminished by an ear infection, so.
Oh, I'm sorry. So I will yell louder. No. That we're talking about RJ2, what we were just talking about, keeping it in. So to ensure that in case someone does not read the bylaw, the JPA, but reads the bylaws and misses that, they understand the process.
Okay. Well, again, the language in the bylaws that was deleted talks about what the Board of Supervisors shall do, and that's not within this body's purview, and so that's why it was deleted. This body and the bylaws that govern this body cannot dictate what the Board of Supervisors must do, and so that's why that was taken out. The JPA is an agreement in which the Board of Supervisors, a contract that the Board of Supervisors entered into with the City of Camarillo and the City of Oxnard in a separate instance, and so that document, the JPA, can bind the Board of Supervisors in some ways, and does bind the Board of Supervisors in some ways. But the JPA,
Okay, I understand.
I'm sorry, the language in the JPA that may or may not bind the Board of Supervisors has no effect on what this body may or must or can do.
Okay.
Okay, so.
Yeah, so the crux is going to be for the supervisors to remember what the JPA says.
Well, and can you put it as per the JPA in front of that?
Say something, for example, the Joint Powers Agreement states as follows.
Yes. Thank you.
I'm happy with that.
Thank you.
Certainly.
That works for us.
Okay.
I'll get there. Okay. Is there anything else on next one?
Oh, mine is, I got one all the way down to Article 8, so if anybody has something before then, I'll wait.
Go ahead. You're
I
on a
have
roll.
something on 7.
You have something
have
on
something on
7?
3.
Okay.
Oh, he has something on 3.
3. Let's go.
Under
3.
duties, responsibilities, page 5C4. And we heard a lot of comment from the public in regards to this matter. Second paragraph, about a third of the way down, the authority shall, at all of its meetings, set aside time for public comment. It shall allow public comment on matters within the authority's subject matter jurisdiction. Now, it's my understanding, again, as we just saw a presentation, people can come up and they can say whatever they'd prefer, whatever they like, whether it's within our jurisdiction or not. If that's true, then I just don't know why we wouldn't say that, why we need to be so specific here in this instance.
And if I remember right from our special meeting, it was expressed by council it was suggested for airport items. So perhaps we need to make this even wider.
I would almost suggest, it shall allow the public comment on any and all matters relating to the Camarillo Airport.
To make it clear.
Because in many cases, we don't want to give the wrong impression to the members of the public.
Any
I don't know,
suggestions?
that's fine. My only comment would be that formulation is actually narrower.
That's more narrow, right?
More narrow than the subject matter jurisdiction of this body. And
Right.
if that is true, then that could raise a Brown Act issue.
Right, and the reason,
That were enforced.
and the reason why we extended it to where it was in case we're talking about FAA items or AOPA items or something that's not specific just right to the land of the airport here.
Okay.
So I think what we have is broad enough to encompass. Is there any other suggestions out there?
In my view, the stating it as the subject matter jurisdiction of the body
Is,
it's both as broad as you can make it and still comport with the language of the Brown Act.
what do you think, Sean?
So by broadening it, we would be potentially in violation of the Brown Act?
He feels you're narrowing it.
No, sorry, yeah, by broadening it, so take out what I, throw out my suggestion about relating to the Camarillo Airport. But by broadening this then further, we would potentially be in violation of the Brown Act?
A Brown Act violation would occur, as Mr. Smith recounted earlier, if you did not allow public comment on an item within the subject matter jurisdiction of these bodies. And so that's where you would find a Brown Act violation. So if your bylaws allowed all comment that is allowed by the Brown Act, or that is required by the Brown Act, then it would certainly reduce the likelihood of a violation of the Brown Act. It wouldn't eliminate the possibility, but it would reduce the likelihood. I'm sorry, sir?
It'll be open then to more.
John, is your mic on?
Yes.
Is your mic on, Mr. Zaragoza?
No,
There you go.
it just gives more latitude to the subject.
Correct.
Yeah, okay. All right. Anyway,
So you could say as open public comments as per the Brown Act. And that's even wider than the authority's subject matter.
Could we just say any matter?
Why not just leave it as the authority subject matter?
Authority's subject matter.
Yeah.
I'm fine with that. Okay.
I mean, I don't think we have to say our goal is to follow the Brown Act. That should be understood.
That should be given. But, okay. Anything else on 3? 4? Can I hear a 5? Maybe
No, 6.
6?
I guess this is 6. It's just,
Yes. Oh, yes.
Oh, no,
we're
six
getting through here. Sorry
is
about this.
compensation.
Okay.
this
Officers?
is terms of office, whatever it is.
Okay.
I'm on page,
Yeah, that's 5.
well, when you look at the next one, there's a red one added, so that's Article, oh, I see, Article 6 is red. I'm sorry.
Yes.
Okay, so Article 5.
Yes.
The second large red paragraph, second line says, excuse me, let me start with that. An alternate public member appointed to the public member seat in this fashion, this is talking about in the instance when the public member for some reason left office, not at the appointment time, left early. An alternate public member appointed to the public member's seat in this fashion shall serve only the remainder of the term of the vacating public member. So that means, as I read this, that person would not be able to then be appointed for a second term.
No, the intent of what is written there is that if, for example, Mr. Thomas leaves within his first year and Mike, you take over. So your one-year term would not qualify towards the full public member term, so he would be eligible to serve to an additional 6 years under his own public member term.
That's not what this says. It says he can only serve the remainder of that vacating member's term.
If I could address that, that sentence is really just to say that the alternate public member who rises.
I think they want you to talk into the mic.
The alternate public member who rises to the public member's seat simply serves out that public member's term.
Yes.
If you see elsewhere in here, the public member's term begins on March 1st
Right.
every year. And so it's simply to say that if the public member leaves office before March 1st, the alternate public member can be appointed and serve out the remainder of that term. The sentence
Well,
does not,
I think we
the
need
sentence
to
does not
add
go on to
something.
say that the alternate public member cannot then later be appointed to another term. In fact, the next sentence implies that the length of service as an
No.
alternate public member shall not count towards a term.
That doesn't have anything to do with what I'm talking about. I think that we might, I didn't know what this meant. After you explained it, those people in this room might understand what it meant. There's going to be some point when none of us is around any longer, and those people are going to think that that person isn't allowed to serve except for the remainder of that term. So it seems to me it should say, he shall fill out the term of the of the member who left, public member who left, and still be eligible to be appointed to further terms.
Charlotte, if you take out the word only, would that be adequate?
Yeah, well, you're going to serve out the remainder of the term. I think that's
Right.
the intent of this.
Yes, so I think taking
Cross out
out
the
only,
Take out only,
take
yeah.
out only.
Then your options remain.
Shall serve the remainder of the term. And
Right.
then I'm fine with it.
Yeah.
Great, thank you, Mike and Charlotte, thank you.
Thank you.
All right. Then we have 7 for officers, any
Right.
change?
I have one on, Bill has one. Go ahead.
No, I'm done on 8.
Okay,
Oh,
7.
On 7, it talks about the authority shall select a chairman and vice chairman and how that is done. And then later in that paragraph, the 1, 2, 3, 4, 5, 6th line, very last word says, from time to time, the chairman will assign members to committees for purposes of special studies and pursuits. Each committee will be headed by a committee chairman. The committee chairman shall be responsible for the authority for carrying out the committee's assigned task. It does not say how the chairman will be selected. Some bodies appoint a chairman, others, the committees select a chairman on their own. It's so specific as to when and how the other is chosen, I thought we should address that.
Wouldn't the committee then?
Council?
The way that the airport advisory, the advisory commission, they do not have a procedure, but what they did is they just asked for a volunteer for
Within the committee?
and then for 2 other members to join that committee, and that's how they handled it. But they don't have a process.
They ask for a volunteer and 2 other, I don't get it.
So they asked for a volunteer to be the chair of the subcommittee.
Oh, okay.
Within the
And,
committee?
and the chair was the one who actually made that motion. So he's the one who selected on how that process was going to go.
Okay. That was my question on that.
Okay. Any change?
Okay.
Bill?
Okay, so this one is another
8?
one of those one-word changes on Article 8, which is me. Oh, go ahead, I'm sorry.
I know you discussed, I've heard
Bert, you had a question?
Councilman Perrello that maybe should be written down, that within the committee, then the committee can pick a chair. Is that what you?
That's not what he said.
No?
He said the chairman selects
The committee.
a chairman, and the chairman selects the committee.
Is that what you?
At least that's what I thought he said.
That's how the advisory commission did it. So it's up to the chair the way that we see it.
Okay, so the chair, okay. yeah.
It's up
Okay,
the,
but that's there then.
Madam Chairman, can I ask a question?
yes.
If we have the opportunity to make it clear, so it's clear in plain English, why don't we do that?
Yeah.
I mean,
Is there any way to make it more clear? Any suggestion?
It would be up to your authorities to see if you're looking for volunteers or if you're looking to just, have the chair select that committee. If
Well,
they
if-
get
if-
appointed or how,
If we want volunteers, why don't we just put it in that that the volunteer of the appointed committee is the chair? But just say it. I mean,
Sure. We can write it down.
How about, so from time to time, the chairman will assign members of the committees on a volunteer basis.
Well, we're all in Camarillo, we're all volunteers.
Okay, on a volunteer basis for the purpose of special studies and pursuits.
Yeah.
So at least you know that they were volunteered to do it. Would that be, or do you suggest a different wording?